in the Supreme Court of Judicature for the State of New York, the case of Pierson versus Post. Justice Tompkins delivered the opinion of the court. This cause comes before us on a return to a certiorari directed to one of the justices of Queens County. The question submitted by the counsel in this case for our determination is whether Lodowick Post, by the pursuit with his hounds in the manner alleged in his declaration, acquired such a right to, or property in, the fox as will sustain an action against Pierson for killing and taking him away. The cause was argued with much ability by the counsel on both sides, and presents for our decision a novel and nice question. It is admitted that a fox is an animal ferae naturae, and that property in such animals is acquired by occupancy only. These admissions narrow the discussion to the simple question of what acts amount to occupancy applied to acquiring right to wild animals. If we have recourse to the ancient writers upon general principles of law, the judgment below is obviously erroneous. Justinian's Institutes and Fleta adopt the principle that pursuit alone vests no property or right in the huntsman, and that even pursuit, accompanied with wounding, is equally ineffectual for that purpose unless the animal be actually taken. The same principle is recognized by Bracton. Puffendorf defines occupancy of beasts, ferae naturae, to be the actual corporal possession of them, and Binkershoek is cited as coinciding in this definition. It is indeed with hesitation that Puffendorf affirms that a wild beast mortally wounded or greatly maimed cannot be fairly intercepted by another whilst the pursuit of the person inflicting the wound continues. The foregoing authorities are decisive to show that mere pursuit gave Post no legal right to the fox, but that he became the property of Pierson, who intercepted and killed him. It therefore only remains to inquire whether there are any contrary principles or authorities to be found in other books which ought to induce a different decision. Most of the cases which have occurred in England relating to property in wild animals have either been discussed and decided upon the principles of their positive statute regulations, or have arisen between the huntsman and the owner of the land upon which beasts ferae naturae have been apprehended, the former claiming them by title of occupancy, and the latter ratione soli. Little satisfactory aid can therefore be derived from the English reporters. Barbeyrac, in his notes on Puffendorf, does not accede to the definition of occupancy by the latter, but, on the contrary, affirms that actual bodily seizure is not, in all cases, necessary to constitute possession of wild animals. He does not, however, describe the acts which, according to his ideas, will amount to an appropriation of such animals to private use, so as to exclude the claims of all other persons, by title of occupancy, to the same animals. And he is far from averring that pursuit alone is sufficient for that purpose. To a certain extent, and as far as Barbeyrac appears to me to go, his objections to Puffendorf's definition of occupancy are reasonable and correct. That is to say, that actual bodily seizure is not indispensable to acquire right to or possession of wild beasts, but that, on the contrary, the mortal wounding of such beasts by one not abandoning his pursuit may, with the utmost propriety, be deemed possession of him, since thereby pursuer manifests an unequivocal intention of appropriating the animal to his individual use, has deprived him of his natural liberty, and brought him within his certain control. So, also, encompassing and securing such animals with nets and toils, or otherwise intercepting them in such a manner as to deprive them of their natural liberty and render escape impossible, may justly be deemed to give possession of them to those persons who, by their industry and labor, have used such means of apprehending them. Barbeyrac seems to have adopted and had in view in his notes the more accurate opinion of Grotius with respect to occupancy. That celebrated author, speaking of occupancy, proceeds thus: requirtur autem corpalis, quaedam possessio ad dominium adibiscendum atque ideo vulnerasse non sufficit. But in the following section, he explains and qualifies this definition of occupancy. Sed possessio illa potest non solis manibus, sed instrumentis ut discipulis retibus laqueris dum duo adsint. Primum ut ipsa instrumenta sint in nostra potestate, deinde ut fera ita inclusa sit ut exire inde nequeat. This qualification embraces the full extent of Barbeyrac objections to Pufendorf's definition, and allows as great a latitude to acquiring property by occupancy as can reasonably be inferred from the words or ideas expressed by Barbeyrac in his notes. The case now under consideration is one of mere pursuit, and presents no circumstances or acts which can bring it within the definition of occupancy by Pufendorf or Grotius, or the ideas of Barbeyrac upon that subject. The case cited, I think, clearly distinguishable from the present, inasmuch as there the action was for maliciously hindering and disturbing the plaintiff in the exercise and enjoyment of a private franchise, and in the report of the same case, states that the ducks were in the plaintiff's decoy pond, and so in his possession, from which it is obvious the court laid much stress, in their opinion, upon the plaintiff's possession of the ducks, ratione sole. We are the more readily inclined to confine possession or occupancy of beasts ferae naturae within the limits prescribed by the learned authors above cited, for the sake of certainty and preserving peace and order in society. If the first seeing, starting, or pursuing such animals, without having so wounded, circumvented, or ensnared them, so as to deprive them of their natural liberty, and subject them to the control of their pursuer, should afford the basis of actions against others for intercepting and killing them, it would prove a fertile source of quarrels and litigation. However uncourteous or unkind the conduct of Pierson towards Post in this instance may have been, yet his act was productive of no injury or damage for which a legal remedy can be applied. We are of opinion the judgment below was erroneous and ought to be reversed.